The Supreme Court on Wednesday rejected the centre's plea for prospective effect of its July 25th verdict, which upheld the power of states to levy tax on mineral rights and mineral-bearing land and allowed them to seek refund of royalty from 1st of April 2005 onwards. A 9-judge Constitution bench headed by Chief Justice DY Chandrachud said the argument for prospective effect of the July 25 ruling is rejected. It said payment of dues by the centre and mining companies can be made to mineral-rich states in a staggered manner over the next 12 years. The bench, however, directed the states to not impose a penalty of any kind on payment of dues. The centre has opposed the demand of states for refund of royalty levied on mines and minerals since 1989, saying it will impact the citizens and the PSUs will have to empty their coffers, which will be around 70,000 crores according to initial estimates. The verdict had overruled a 1989 judgment which held that only the centre has the power to impose royalty on minerals and mineral-bearing land. Some opposition ruled mineral-rich states then sought refund of royalty levied by the centre and taxes from the mining companies since the 89 verdict. And to speak more on this, my colleague, the legal editor of TV9, Ashok Bagdia, is in the studio to decode this, what seems like a very complicated issue, to make it easy for all of us. Over to you, Ashok. Royalty, the word, one only heard royalty when it comes to books and music. But just explain it for the benefit of those. What does this mean? Because if I recall right, it was a corporate which at first, raised this concern. Ashok.
Well, in fact, this particular issue arose out of a judgment delivered by the Supreme Court on 25th July this year. In that judgment, the Supreme Court adjudicated on two very complex issues. The first issue was whether royalty can be construed as a tax or not. On that count, the Supreme Court held that royalty is different and tax is different. The second thing that the Supreme Court ruled or said was that the state governments are empowered to enact laws whereby they can impose tax on mineral rights and lands bearing minerals. So what really happened after the 25th July judgment was that the rules of the game which held or were rather on the ground for the last 30 years, they were suddenly changed. For 30 years, there was another rule which said that the state governments cannot tax. But 30 years down the line, the Supreme Court in 2024 says and changes the rules and says state governments can tax. Now, the issue that arose out of the 25th July judgment was whether the states can impose demand for taxes retrospectively or will it be prospectively. Now, the Union Government of India favored prospective application of the judgment.
All right.
And then they said, to buttress their argument, they told the Supreme Court that this judgment should have prospective implications because if it is applied retrospectively, it will have an impact on the financial economy. Second, they said everything from nanotechnology to healthcare will be impacted. There will be an undue burden on public sector units.
Okay.
The burden which was told to the Supreme Court was, by a rough estimate, would run into 70 to 80,000 crores across the states. And in one instance, the Solicitor General of India also told the Supreme Court that there was one Maharatna PSU which, if the tax demands were raised against that Maharatna, the tax demand would be 3 times the net worth of that Maharatna.
Oh my God.
So that is what happened. But there were some states who opposed this prospective application of the judgment.
All states or mineral rich?
They are basically states which are mineral rich and they had passed laws to tax those mineral rights and mineral bearing lands.
Okay.
So those were the states like Jharkhand, was at the forefront in opposing the demand for prospective application of this judgment. And it said that, look, the state governments are anyways cash strapped and revenue strapped. On one hand, the Supreme Court is saying that the state governments have a right to impose tax. But then what happens to the situation 30 years back? Are you saying in the same breath that the laws made by the state governments were wrong? So, two anomalous situations cannot exist. Moreover, a suggestion was also put forward by the Jharkhand government, where it was said that, look, let there be no retrospective or prospective implementation of this law, but let the law of the land as dictated by the Supreme Court have its full flow, but you can impose conditions on how it will be carried out. So, today the Supreme Court has basically imposed conditions on how this particular judgment will be implemented. So, among the conditions that the court has put, the court has said that, look, we are reiterating our stand that the state governments have a right to impose tax on mineral rights and mineral bearing lands. Secondly, the state governments can retrospectively impose taxes on industries, but the cutoff date is April 1st, 2005 onwards. The third thing the court said is that this payment or demand for tax which the state governments raise will have to be staggered over a period of 12 years. So, let us say tomorrow a state government were to raise a tax demand from a PSU running into 500 crores.
All right.
So, now if those 500 crores were to be taken from that PSU straight away, it will cause an undue burden on that.
Yeah.
So, that 500 crore rupee tax demand can be staggered over 12 years and 60 crores every year can be paid to the state government. So, this is an arrangement that has been carved out by the Supreme Court of India, bearing in mind two facts. The first fact was that state governments are revenue strapped. Second thing, that it will impact the public sector units and other industries which have been involved in the mining sector. But there is a fallout of this judgment, so that I want to say that one final word.
Sure.
Is that the fallout of this judgment is that it's very good news for the states, because most of these mineral bearing states have a heavy revenue deficit.
They are cash trapped.
Cash trapped. So, once they realize these tax demands, it will be a windfall gains for these state governments, and possibly they can use this revenue or this revenue generated by taxes for the welfare measures of the people.
Ashok, thank you so much for decoding this and speaking so eloquently on this topic.